Commission of Inquiry into the political interference and a claim for constitutional damages on behalf of the families. The litigation ultimately forced the President's hand, and within a few weeks of the filing of the papers, he withdrew his opposition to the case and agreed to establish a commission, stating that he wished to engage in mediation with the families. Indeed, he said he didn't want to fight the families. He wanted closure for them. And for that reason, he and the other government respondents, except for the NPA, withdrew their notices of opposition, a move that was greatly welcomed by the families. Sadly, however, the conduct of the President and the government has been erratic and subsequently damaging to the families in the country, because when the families reached out to the President and his team seeking to mediate and to resolve this matter, as one should do, given the issues at stake and given the constitutional imperative of dealing with these matters, the President inexplicably changed his mind and through his team said, no, he will not mediate, he will not negotiate. And so the government entities then closed ranks and adopted what can only be described as a highly technical approach, which was aimed at delaying resolution of the matters. Not only that, the President unilaterally inserted the question of the family's claim for constitutional damages into the terms of reference of this commission, knowing full well that this body cannot determine rights and remedies. It can only offer advice, which the President is free to reject or ignore. I'll just wait for the phone call to end. Now, we have written to the Commission indicating that we feel that the proper place for the determination of rights and remedies in respect of the constitutional damages claim is with the High Court, and indeed that claim is presently before the High Court. And papers are being exchanged as we speak, and that litigation will be proceeding during the course of this year. The President then took the step of approaching the court to reinstate his opposition to the family's application, and he brought an application to stay the proceedings pending the outcome of this commission. That further delayed the litigation. In early October 2025, the application for a stay of proceedings was dismissed out of hand by the High Court, which noted, and I quote, that it is rather ironic that the government, who is the sole cause for the delay, wants this court to sanction yet a further indefinite delay without being able to point to any tangible benefit. Commissioners, if I may just deal briefly with the opening statement of my learned friend, Mr. Nell, for AFRI Forum. We take no issues with the submission by Mr. Nell that crimes experienced by all sides of the conflict should be treated equally and investigated and prosecuted. We agree with that contention. There should be no favoritism. There should be no decision based on any political affiliation. And unlike the apartheid era, when only one side was targeted, prosecutors in the new constitutional era must never be motivated in their decisions by political affiliation. And if Mr. Nell's clients are victims of serious and gross human rights violations, and if those investigations and prosecutions were suppressed, then those matters must also be addressed. Madam Chair, we are deeply concerned that former Presidents Jacob Zuma and Thabo Mbeki launched belated last-minute applications in December 2025 for the recusal of the chairperson. Moreover, only last week, Mr. Zuma launched an application before the High Court seeking to review the refusal of Judge Khampepe to recuse herself. And Mr. Mbeki has also indicated in writing that he will launch a similar application. Now, the families take the view that this 11th hour litigation is aimed at derailing the Commission's proceedings. They point out that both former presidents are under a moral obligation to disclose what they know about the subject matter of this inquiry. And the families call upon the former presidents to return to this inquiry. They owe it to the families of those who laid down their lives for a democratic South Africa to explain why they were denied justice, truth, and closure. In conclusion, Madam Chair, the families are satisfied that unlawful and improper institutional interventions stopped their cases from proceeding for extended periods. Indeed, 3 superior courts have already also come to this conclusion. I've mentioned the Rodriguez matter, the full court and the SCA, and then also in the Mbeki intervention application, that court came to a similar conclusion. The citation is in the footnote. However, while we know that interference did stop the cases or undermine them, the full reasons for that obstruction are not known. And the families want to know the actual reasons why they were denied justice. Also, the source of the interference remains unclear and opaque. It appears that arrangements or understandings may have been struck with individuals and entities outside of government to block the cases from proceeding. And the Commission has requested, please uncover the genesis of the interference. The full means by which the will of outsiders was imposed on institutions such as the NPA and the SAPS must be exposed. The families want to know how institutions with firm constitutional and statutory obligations to uphold justice and to act independently so easily abandon their duties in respect of the TRC cases. Perhaps more than any other class of cases, the suppression of the TRC cases has been almost total in its impact. Virtually all the cases were blocked for an extended period of time. Most of the cases cannot be resuscitated, as many perpetrators, witnesses, and family members have died in the intervening period. And we take note of the submissions of my learned friend for the NPA that certainly under the current tenure and perhaps over the last few years, that steps have been taken. And to the extent that they have been taken, they're greatly appreciated. But it is a little too late. It's too little and too late, because it's not going to save the bulk of the cases in which we no longer have perpetrators, we no longer have witnesses. Those cases are dead and buried. The damage has been done. The impact visited on the families, their communities, and on the fabric of society is incalculable. The harm done to the families and South Africa as a whole demands an expeditious, thorough, and credible inquiry into the machinations that resulted in such a massive denial of justice. The families of apartheid-era victims deserve nothing less than a full, open, public, and transparent inquiry. This must include public hearings, the power to subpoena and compel the production of evidence, and the right of victims to be represented in the Commission, to lead evidence, and to put questions to witnesses as appropriate. Where individuals fail to cooperate with the Commission, and where public entities fail to produce needed documents, we request, Madam Chair, that they must be compelled through subpoena to appear before the Commission. From the perspective of the families, the post-TRC period has been one of the most shameful times in South Africa's history. The families have lost all faith in the institutions that were meant to uphold the rule of law. There is a critically important need to restore public confidence in these institutions. And Commissioners, this Commission can play a key role in beginning the process of restoring trust through a credible and robust investigation that leaves no stones unturned. That's our opening statement. Thank you, Madam Chair.
Thank you, Mr. Van, for your comprehensive opening statement. We shall now call upon Judy September. Is she here? Yes, Judy. Are you going to make an opening statement? Yes, you must come forward and be next to a microphone. Ms. Statement, how long will your opening statement take? How long will your opening statement take?
I would think between 30 and 45 minutes.
Okay.
I'm Judy Seidman. I'm presenting on behalf of Kulumani Gala Reparations Movement.
If you can raise
Can
your voice.
can you raise your voice or pull the microphone closer to your mouth?
I'm Judy Seidman. I'm presenting on behalf of Kulumani Gala Reparations Movement. Kulumani Gala is a mass-based social movement comprised of and representing victims and survivors of apartheid crimes against humanity. Our movement first came into being in 1996 with the establishment of support groups around the country to assist victims and survivors telling their experiences of human rights violations to the TRC, what were the original groups called the Kulumani support groups. Many of our members today are actually come from that original source of people going to the TRC. In 2000, these support groups joined to form the NPO called Kulumani Support Group. 2 decades later, many of these victims and survivors and activists determined to launch the Kulumani Gala campaign. Kulumani Gala asserts that the post-TRC processes have clearly failed to fulfill constitutional promises of justice, redress, truth, and repair for victims and survivors. We call upon government to fulfill its long-standing promises to both meet with us as victims and provide those promised outcomes of justice, redress, and restoration of human rights and dignity. For the past several years, our members have protested government's failure to meet these commitments. In particular, members have risked life and well-being for over 2 years, holding an ongoing protest, occupying the space in front of the Constitutional Court, while our government continues repeatedly to ignore us, despite many, many, many efforts to engage with them and to ask them just to meet with us to approach these questions. So in this context, Kulumani Gala fully welcomes and expects to contribute to this Commission of Inquiry into what we consider failed TRC outcomes. So in terms of the Commission, our input refers to what we see as 2 key
Ms.
mandates.
Statement, could you please speak up a bit louder?
Okay. In terms of this Commission, our input refers to 2 key mandates. First, the Commission will inquire into whether, why, and to what extent and by whom efforts or attempts were made to influence or pressure members of the SABC and the NPA to stop investigating or prosecuting TRC cases, and whether government actors might be held accountable for such interference. Secondly, we feel the other key terms of reference that we need to input to is the one that says, quote, whether in terms of the law and fairnesses the payment of any amount of constitutional damages to any person is appropriate, as this obviously speaks directly to our members. So first, let me talk about the question of stopping investigations and prosecutions of TRC cases after 2003. Firstly, I do want to say we very much appreciate, build upon the incredible work that has been done by the families at FHR. And I'm not going to try and repeat all of that in the introductory statement. I might mention it where it's particularly relevant. We do want to say that, to start with, it's important to recognize that the term TRC cases refers to all the cases that fall within the scope of the promotion of the National Unity and Reconciliation Act of 1995, the so-called TRC Act. The Act defines victims as, quote, persons who suffered harm in the form of physical or mental injury, emotional suffering, pecuniary loss, or substantial impairment to human rights. And it then includes people who supported such persons and suffered violations as a result, and, of course, the descendants, dependents, relatives, and descendants of such victims. The TRC cases further are limited to human rights violations that occurred between 1960 and 1994, and cases that were undertaken with a political motive. We hope, although we still have to discuss the details of this, we have literally hundreds of testimony from our members, from victims and survivors, about their efforts to give statements about violations that they experienced to the TRC as specific examples of these TRC cases. These TRC cases are examples taken from a number of different categories and sectors that we consider fall within the definition of the TRC cases. And just to mention some of them, cases that the TRC did not recognize as qualified gross human rights violations under the Act. These include cases where victims were unable to give statements to the TRC for a range of reasons, statements where victims were unable to provide sufficient evidence to prove that their testimony was correct while giving statements at the TRC. And we note that both the NPA and the Advocate Varney's statement point out the lack of evidence that was available for so many of these. But many people did go to the TRC and simply did not have the backup information other than their own word as having experienced it. There are also other statements that were submitted to the TRC that were rejected because they were felt that they did not fill the criteria of gross human rights violations made with a political motive. And we highlight here what the category of the rape cases, which the TRC determined, apparently, we are told, on the ground that they did not include rape as a political crime because it was personally motivated and that people were not ordered by their seniors to commit rape. Now, we all know from world experience and from South African experience that is not actually a description of many rape in political contexts. But the fact is that many, many women presented statements about rape to the TRC and were told they would not take the statements because they did not fit the political motive criteria. Violations that fall under these categories that were not handed over as defined cases to the state to investigate or prosecute. We note that the TRC Final Report, Volume 7, admits that it was unable to take forward many of the cases because of difficulties faced within the TRC, including lack of access by victims, lack of investigative capacity within the TRC, failure from many victims to give statements within the limited time frame of the TRC. The TRC itself, in its final recommendations, calls upon government to put in place a national discourse and other measures that would lead to follow up on unheard cases. Specifically, the recommendations state, quote, that victims should not be re-victimized and that any amnesty should take into account their needs and their right to the truth and full disclosure and ultimate reparations. That's in Volume 7 of the final TRC report. The third area that we want to speak to are cases that were heard by the TRC and that were passed on to the police and the NPA for further investigation and prosecution at various stages of the TRC process. And I think Advocate Varney has talked quite a lot about that. But what we want to say about these is that the list that they have presented as affidavits to this commission involve many of our members, and that these cases were not dealt with in the period after the closure of the TRC. So in this case, we feel we have a direct interest in this question of why these cases were closed down, and that it is critically important that victims' voices are heard in this, because one of the big problems that we find in the post-2003 period is that victims, with the exception of the cases that have been brought by FHR, victims' voices have been simply told, you don't even exist in terms of the TRC, in many, many cases. And we can actually provide examples of that, of being told by senior officials of government, you are not really victims, so go away, go home, and stop bothering us. Cases where amnesty was refused to applicants is another category. Again, has been discussed, and I'm not going to go over the figures, but over 7,000 people did apply for amnesty. The TRC denied amnesty to, the figures I have, of 5,392 perpetrators, mostly on the grounds that they didn't tell the whole truth. As a result of that failing to tell the truth, many of the victims whose cases would have been recognized had they told the truth, therefore have no proof that their cases were there. So there's a direct link, in our view, between the failure to prosecute perpetrators and the silencing of victims about their cases. And we'll come back to that. We do want to point out that there is major overlap between the categories we've just mentioned. People who are not qualified as victims of the TRC or do not appear before the TRC do appear as unnamed victims in some of the TRC files that we know were handed over to the NDPP and SAPS for investigation. And again, we really want to thank the incredible work done by the families and the Kalata applicants on this. Just as an example, one of the files handed over in 1999 is not actually a case. It's a file that covers, quote, East Rand train shootings from 1991 to 1993. It mentions 60 people killed, of which it mentions one name of a victim. Many of our members lost family members or were injured in those train shootings. Those cases were handed over. As far as we know, they were thrown out. Not all of those people did get to the TRC. Again, the chances of their ever bringing their cases into public once that was closed was gone, as far as they were concerned. There are also numerous cases, as I said, where perpetrators were refused amnesty but were neither investigated nor prosecuted. And these, again, involved many victims who weren't able to access the TRC and therefore could not provide proof of the violations that they actually experienced. And proof, by the way, does not include being shot in both legs, and because you have to then get a hospital or a police statement that you were shot under such conditions, and those were simply not accessible to people who were shot under conditions in the early 1990s or late 80s. And we are told many of the hospital records have also been destroyed. We note that this commission is directed to inquire into refusal to investigate and prosecute TRC cases after 2003. The commission's evidence leaders have said earlier that this does not preclude introducing testimony of efforts prior to 2003 to stifle or bypass or refuse to investigate or prosecute cases. So historically, as Kulumani Gala, we think we need to emphasize two underlying arguments used during the TRC to refuse to accept victim stories as sufficient evidence of victim status. One was that evidence was not required from victims, as perpetrators would tell all, and therefore there would be no need for further evidence to prove victim stories. That, as we know, just did not happen for most people. Secondly, victim stories were framed, and the TRC is quite explicit about this in its victim hearings, as giving, quote, a broad understanding of human rights violations, rather than either identifying each and every case of violation or in finding specific evidence to establish cases against perpetrators. Thus, the TRC was not given the powers to investigate. If somebody came with a story, the TRC, and they did not have the police, that the evidence that the police had done such a thing to them or whatever, the TRC simply did not have the powers to further investigate. We need to emphasize, however, while these problems hindered recognizing victims prior to 2003 and thus prevented and interfered with investigating and prosecuting perpetrators, the TRC's final recommendations both admitted to and proposed ways to correct these difficulties. Kulumani Gala therefore suggests that this commission needs to look at not the blockages within the TRC to recognizing victims, but the measures taken upon the closure of the TRC not to recognize those victims, despite the fact that their cases had not been properly made. Kulumani also plans to testify that the fundamental shift that occurred in terms of investigation and prosecution of perpetrators was introduced by a series of linked government decisions made in 2003 after the closure of the TRC. These were articulated and placed before the nation by then President Mbeki, Thabo Mbeki, in a speech to Parliament on the 15th of April 2003. This speech, which explicitly claimed to chart the way forward for government action after the TRC was formally closed, puts forward a number of core alternative proposals to the TRC recommendations. These include, firstly, to only recognize as TRC victims those persons qualified by the TRC as victims. That is the so-called closed list. That if you did not get to the TRC or your story was not accepted or you did not have proof, you did not count as a victim. That became a formal regulation, a formal proposal of government in 2003. It had been put forward to the TRC and had much discussion, and in their final volume, they questioned it, in fact. But it was formalized in the April 15th speech by Thabo Mbeki. Secondly, to provide special pardons or special indemnity, however it was framed, to perpetrators who did not apply for or were not granted amnesty. And I think, again, Howard Varney has talked very in detail about how that process went forward. That was first mooted in the 15th of April speech. To cut back on reparations given to victims, only to qualified victims, to less than a quarter of the amount recommended by the TRC that they considered adequate and appropriate. So it went down from approximately 126 to 135,000 per person to 30,000 once off, finished. and again, only to people on the so-called closed list. And then to ensure that a number of other measures that were taken, these were also mentioned in the same speech, that also prevented further follow-up on TRC outcomes, such as introducing a wealth tax, seeking financial compensation from transnationals as a means to reclaim from those who had benefited from apartheid crimes. So all of those were put together in the same speech and presented to Parliament essentially as an alternative to the TRC recommendations in Volume 7, which we believe actually tries to rectify some of the problems that they had encountered. Hopefully we will, sorry. Technology is not cooperating. And I don't know why. Okay. So taken as a whole, the measures proposed in Thabo Mbeki's 15th of April 2003 speech ensured that any evidence by victims that had not been placed before and accepted by the Human Rights Committee or was not revealed and confirmed by perpetrators seeking amnesty would not be accepted as an outcome of the TRC. It blocked other mechanisms that might provide ways to ensure that government could prosecute and hold to account apartheid-era perpetrators, including specifically the first proposal about a pardons process. In terms of testimony on this, we have actually collected literally hundreds of statements from our members about how this affected them personally. We would like to present possibly 8 or 9 or 10 of these as core examples to this commission to show what the impact was. We still have to negotiate as to what's feasible. We realize it is not the role of the commission to rehear the TRC or redecide the TRC, but rather this is to talk about how people were actually affected by this directly and how they were persistently not included. One of the points that's frequently made is that after those cases in their various forms were handed over to the NDPP and the SAPs to follow up, not a single case that we know of went back to the victims who were named and asked them for any input. It's just silence. So, and we feel, I should just add, that in the several cases, again, I think Howard Vani has mentioned them, where these have come before the courts have mentioned that not hearing victims on the issues of perpetrators has been one of the actual violations of constitutional rights. But this actually, to us, forms proof of this. We could also submit written testimony from our members, not for actual presentation, if that would be useful. We can discuss that. Okay, so secondly, the second area that we want to These were not accepted by government, starting with that speech on the 15th of April in 2003, and it didn't happen. The 2008 judgment in the Naktula Simelane matter that Howard mentioned actually opposes the special pardons dispensation as essentially a backdoor blanket amnesty, and it ruled that the specific pardons process denies victims' rights, which consistently affirm that victims must be included in any individual pardon or amnesty decision. The court then ruled that failure of the special pardons dispensation to engage with victims' views and concerns was unconstitutional. Again, we can go into the details of this. We hope we will in giving full evidence later. We will also present as Kulumani Gala Reparations Movement to the Commission the mandated resolutions of our own members calling for constitutional damages for victims and survivors who have suffered now for 25 years since the closure of the TRC of the failure to provide promised justice, redress, and restoration of human rights and human dignity to apartheid's victims. Again, we can provide examples of individual testimony of the impact this has had on people's lives, and we need to discuss what is feasible within the context of the Commission, and so on. We do want to mention that, as well as the illness and death and living in poverty and everything else that many victims have had to deal with since the closure of the TRC, with no way to ask for redress at all, or we were told there was no way. We have also, in the course of our demonstration at Concord, we have lost 9 members, living in very unhealthy and life-threatening conditions, including the court refusing to allow us to use toilets and water and so forth, on the grounds that they don't consider this a legal demonstration, despite the fact that we have informed the court and the presidency and so forth that we are doing this, and that we are, and they actually had said they would meet with us and then they wouldn't meet with us, so on and so on. I'm not going to all of that. I think I should just mention 2 of the people who died at Concord specifically. One of them, Mr. May from Cape Town, actually developed, he was in his early 80s, I think. He developed a form of asthma which affected his heart after sleeping rough outside Concord for, I think it was 6 weeks. We did get him to hospital, and eventually he was flown back to Cape Town, but he died at home. Another member, Tabo Shavangu, had essentially a stroke after spending a year and a half at Concord, and died there.
So, sorry, I don't want to interfere, but will it help?
Sorry?
Will it help if you are those members who have passed on?
Yes.
To get their names, and if possible,
Yes, we intend to submit all of this information.
Yes.
In detail.
Yes. Okay. Thank you.
So, sorry, my technical problems are giving me trouble again. I don't understand this. Okay, so I'm just about to finish then. So what we are asking from the Commission then is essentially a recognition that there are victims and survivors, that these victims and survivors have clear grounds to call for constitutional damages, and specifically We are asking for damages for victims, survivors, and their families and descendants who were denied adequate and appropriate reparation and justice promised through the TRC process. And this was denied again after that decision in 2003. This denial has been enabled and enforced first by government's persistent refusal to follow up on investigations and prosecutions flagged by the TRC for further action, and secondly, by government's continual and ongoing refusal to take victims' perspectives into account in any of these issues, and actually blaming victims for the difficulties they face while calling for redress and reparation. And then secondly, we also call for constitutional damages for those victims who have risked their life and well-being attempting to bring these matters to government's attention, where government has repeatedly said they will meet with us, including in signed affidavits at various points, and then a month or two down the line say, well, we've decided not to, without giving us reasons. And it's been a very painful story. I think I'd just like to conclude by saying that we feel this commission offers for the first time in 25 years, an opportunity for these issues to be dealt with appropriately and properly by our constitutional democracy, which we feel we fought for, we're very proud of. It needs to be activated the way it's supposed to be activated. Our Constitution has laid down basic principles which we need to enforce, and we are very pleased and proud and to be able to present this in public and to this commission. Thank you.
Thank you, Ms. Seidman. I think this would be an appropriate time to adjourn for tea, and we'll reconvene at 11:15. Oh, no, at 11:20. We'll reconvene at 11:25. Mr. Hethon will receive your opening statements.
Thank you, Madam Chair. Good morning to you and the
Yes,
commissioners.
bring your microphone closer to you.
Oh. Can you hear me better now?
No, barely.
Madam Chair, we prepared an opening statement in October. I have sent an opening statement, an amended and abridged opening statement to the Secretary this morning.
Yes, how long are you going to require for your opening statement, Mr. Hethon?
I think not much more than 10 minutes,
Thank you, Mr.
perhaps
Hethon.
15 at the outside.
Yes, you may proceed, sir.
Thank you. Yes, so my name, Commissioners, is Murray Hawthorne. I'm an attorney at the Legal Resources Centre in Johannesburg. I'm accompanied by my colleague, Shatira Hassim,
Yes.
who is co-author with me of the opening statements. The Legal Resources Centre acts for the family of the late Duly September. It takes its instructions from Duly September's nephew, eldest nephew, Michael Arendse, who resides in Cape Town. It is he who represents the family in its relationship with the Legal Resources Centre. In my October statement, I made it included a long section on the history of Duly September's activism. As interesting as it is, I will only start with her appointment as the ANC's chief representative to France, Switzerland, and Luxembourg at the end of 1983. She was stationed at the ANC office in Paris. Her time in Paris was marked by her fierce commitment to imposing strict sanctions on the apartheid regime and ensuring that countries stuck to them, making enemies both in government and those business interests in southern Africa. On March 29, 1988, between 9:45 and 10 a.m. in the morning, Duly September was shot 5 bullets in the head with a .22 caliber silenced rifle in the hallway as she was entering the ANC's offices in Paris. There were no witnesses, save for one resident of the building, a Mr. de Crepy, who heard footsteps running down the stairs after the shots were fired. I come to the relationship with the Legal Resources Centre. The LRC was initially approached in this matter by Jacqueline de Rennes, French anti-apartheid activist and former colleague of Duly September, towards the end of 2017, after she had heard former LRC Director Steve Karnowitz address a conference in Paris. During a visit by Michael Arendse, the eldest nephew of Duly, as I've said, and other family members in late March 2018, to attend events in Paris, France, to commemorate the assassination. A meeting was held between family members and senior officials from the town of Arsuel, where September had lived, forgive my pronunciation, to explore ways to reopen the case in France and South Africa, and to get the two countries to cooperate in the investigation. It was after that that Arendse secured a meeting with Steve Karnowitz in April in Cape Town of 2018. The LRC directed a prior request to the SA Embassy in France and to DIRCO. The response led to the disclosure of an archived box in South Africa retrieved by the LRC, but containing only documents relating to Duly September's life in South Africa before going into exile. The LRC search in June, July 2015 also led to the South African Historical Archives, specifically their Section 29 documents from the TRC and their Right to Truth Project findings, both of which have been classified for many years and had only recently come to the public eye through the tireless work of the South African History Archive. The LRC's check of the Section 29 records at the archive produced nothing of note concerning the assassination. The French investigation. The family did not ask the South African authorities to investigate Darcy's death, believing this obligation lay with the French authorities. However, the family did brief the LRC to conduct investigations in South Africa. As far back as 1992, the French authorities had closed their docket on the Duly September murder after it was ruled by French Judge Claudine Foucault that there was no new evidence. In this regard, well, let me just carry on. The TRC investigation. The TRC investigated the matter of the murder of Duly September. The TRC assigned the task to a seconded Swedish policeman, Jan Akka Kjellberg. Of particular note, we have taken a statement from Kjellberg. We have had several consultations with him and have made that statement available. It's an unsigned, it hasn't been sworn to yet. If needs be, it can, but I see from the rules that we don't need to have an affidavit sworn. But if we should do it, we will. That statement has been placed before the Commission on the 3rd of this month. In that statement, Kjellberg says the following. On 13 February 1998, during his time, of course, investigating the matter for the TRC, a meeting was held with Dr. Turi Pretorius in his office in Pretoria. Pretorius, of course, being a senior member of the NPA, a senior prosecutor of the NPA, who has been referred to in discussion this morning. So, concerning the investigation into the assassination of Duly September in Paris on 29 March 1988, Pretorius disclosed the following information. This is Pretorius' information as recorded by Kjellberg. Based on intelligence received from an undisclosed source, Dr. Pretorius reported that the weapon employed in the assassination was allegedly sent from South Africa to the London embassy via diplomatic mail. The gun was handled by a representative of the National Intelligence Service of South Africa in London and subsequently collected by another NIS representative stationed at the South African Embassy in Paris. This individual reportedly travelled by car from Paris to London to collect the weapon. Kjellberg notes, no detailed information was provided regarding the identities of those involved, the vehicles used, or the precise timing of the transfer. I would submit, though, that it appears that Dr. Pretorius knew much about the assassination, whilst he was at the time a senior NPA official. And it must have investigated it to some considerable degree. Therefore, we submit that the Commission ought to call Dr. Pretorius to these proceedings to testify what he knew about the Commission, what he knew about the murder, and to testify what he knows about the apparent closure of the investigation at that point. There's no evidence that we know of, that the family knows of any further investigation by the South African authorities, notwithstanding the knowledge which Dr. Pretorius had of the assassination, until 2022. So in fact, for 24 years, including the period from 2003 onwards, there was no investigation. Michael Arendse was informed by the Directorate for Priority Crime Investigation in November 2022. I've got 2002 in the document I sent to the Commission this morning. He was informed by the Directorate for Priority Crime Investigation in November 2002 that it had started to investigate the assassination. And that would, of course, be consistent with the obligations of the prosecuting authority to keep the victims informed of what is going on and to consult them about important decisions. And that also was referred to us this morning, that was discussed this morning. We do know that in October 2025, an application by the Director of Public Prosecutions, Western Cape, to invoke the Mutual Legal Assistance on Criminal Matters Treaty between South Africa and France in the September matter was granted. I have made that document and the associated documents available to the Commission. They were sent to the Commission. I cannot tell you the date, Madam Chair, but recently. This treaty, so the treaty must be read with the International Cooperation in Criminal Matters Act No. 75 of 1996. This act commenced on 1st of January 1996. The treaty was ratified by Parliament on 11 November 2002, and it came into force on 1 March 2004 and published in the Government Gazette number 27371 on 18 March 2005. So the South African Prosecuting Authority has had at its disposal and use this treaty since, with effect from the 1st of March 2004. The first we hear of it being invoked is information given to Mr. Arendse last year that the application had been successful, and as I say, the order granted by the court has been made available to you. The question then arises, why has it taken South Africa until 2022 to begin to investigate the Duly September case, or at least to resume investigation of the Duly September case, after it would appear that Dr. Pretorius started that process and it must have stopped as far back as 1998. We believe that Dr. Pretorius can shed light on the answer to these questions. His answer can, we submit, assist this Commission find the answers required of it in terms of the terms of reference contained in the proclamation notice establishing the Commission. So too we submit that the documents which we have asked the Commission to call for in terms of paragraphs 1, 2 and 3 of our letter, of our email to the Secretary of the Commission dated 3 February 2026 can help answer this question. I will just quickly run through what those documents are. We have requested the Commission to call from the records of the TRC for the report of Mr. Kjellberg himself to the TRC on his investigative activities on its behalf on his trip to Paris in November 1997, where he was asked to go to Paris to investigate disconcerting evidence about who might have carried out the assassination. The background to this is set out, to what happened on that trip, is set out in the statement of Kjellberg, which we made available to the Commission. It appears that Kjellberg was accompanied by Mr. Wilson Magadla, who was not known to him. Certainly his professional capacity was not known to Mr. Kjellberg. It appears that in fact he was not a member of the police. At one point, in discussions with a witness, Kjellberg felt that the witness was about to divulge important information. He became excited, and Kjellberg informed me that any good policeman will know that when a witness in an interrogation becomes excited, very often it's a prelude to important evidence being divulged. At that point, Mr. Magadla stopped the discussion and in fact brought them home without further ado, and stopped the investigation. Mr. Magadla is deceased. But Mr. Kjellberg can testify to this episode, and therefore we ask also that this commission call from the records of the TRC for all reports on the activities of the late Mr. Wilson Magadla in connection with this trip to Paris, in particular the purpose of his making this trip, including whether he might have been assigned to rein in the investigation of Mr. Kjellberg on this trip. We further ask Mr. Kjellberg further gives evidence in his statement that he received a document from the TRC in Cape Town in which the people in whose possession it was were asking him to translate it because they believed it was in French. Mr. Kjellberg assured them it was not in French. It was, they said it was in French. So that is the real point, that the statement was a French document. In fact, Kjellberg said it was the first page of the docket of the French police into the investigation of this matter. It was not recognized as such, and therefore we also ask this commission to call from the records of the TRC the French police file on the murder of Duly September, which we believe to be in their possession, based on the statement of Mr. Kjellberg. Kjellberg is willing to give viva voce evidence to this commission, either in person or remotely. He is resident in Denmark. I would therefore stop on that note, Madam Chair. We ask this commission to arrange for the testimony. It can be done remotely for Dr. Kjellberg to give his testimony to this commission. And we also ask that in the light of that testimony, Dr. Pretorius be called to answer his questions of what he knows about the investigation of the Duly September murder and what does he know about it having been stopped. It's probable that he was the investigating officer and he was in charge of this matter in the TRC, in the NPA at the time. He would surely then be the person who has knowledge of this matter and who should be questioned about what he knows, including in respect of the reasons why the investigation was stopped and in fact not resumed until the end of 2022. And that it is for those reasons that we also ask for the 3 documents which we believe are relevant and which we believe are in the possession of the TRC or the TRC archives. We would ask you to exercise your powers to obtain those, to call for those documents. Thank you.
Thank you, Mr. Hudson. We'll now call Mr. Lipile to come and present his opening statement. Mr. Lipile, how many minutes are you going to require for your opening statement?
Thank you, Madam Chair. 10 minutes will be fine for me.
10 minutes. I'll hold on to 10 minutes.
Thank you, Madam Chair. Honorable Chair of the Inquiry, Justice Khampepe, Honorable Commissioners, and fellow South Africans. I make this statement on behalf of Kulumani Support Group and its members and associates. In my role as Chairperson of the National Steering Committee, Kulumani Support Group is the national membership organization of victims and survivors of apartheid atrocities and human rights violation. Kulumani members lived the history of struggle against apartheid, and those who have survived continue to carry the consequences of their violation. Kulumani Support was founded in 1995 at the time that the Parliament initiated debates about the proposal to host a Truth and Reconciliation Commission. Victims and survivors received no invitations to inform the debates. Subsequently, Ms. Sylvia Dlomojele and Ms. Katerina Mlangeni, as former members of the Detainees Parent Support Committee, initiated community dialogues, each attended by hundreds of survivors. The question they debate was the wisdom of participating when they had been excluded from the planning for the TRC from the start. The consensus was reached that participation was preferable because of the hope that this might contribute to an agenda of redress. That hope has seen almost no realization over these past years. This inquiry takes place 31 years since the debate of 1995 and is characterized by extraordinary limited terms of reference. The ambit of the inquiry reinforces for survivors the sense that the state has long turned its back on the majority of the people who paid with their lives to bring them to power. This perception is reinforced by the experience of extended delays in initiating the inquiry, attributed to the recurrent attempts of political connected to intervene to halt or to delay the important work of truth. The prolonged delays have meant hundreds have died without being heard, their voices now permanently silenced. Thousands have grown old without the recognition and weight the wounds from the past carried by ordinary people keeps growing, intensified by the levels of disrespect meted out by those in position of authority to the wounded, who carry deeply unsettled accounts about our history. Many who have gave the best years of their lives to the life of struggle for justice and dignity have voiced to us their sense that they wasted their lives in service to a vision that has faded beyond any recognition in the present. How did this become our current political reality? Tragically, South Africa in 2026 has not aligned itself with the African Union agenda of its declared decade of reparatory justice, 2026 to 2036. South Africa has, in contrast, continued to regard reparation as a mere symbolic demand rather than as a matter of justice, dignity, and development. The situation has been characterized by a complete lack of wholeheartedness in dealing with serious violation of apartheid, with the Truth and Reconciliation Commission that generated only 17,600 acknowledged victims of apartheid gross human rights violation to the present. Only these individuals with their children and grandchildren have been recognized as eligible for the limited reparatory measures that have emerged from the TRC implementation unit in the Department of Justice. It has been under the direction of the state that the TRC unit has been complicitly in almost completely ignoring the draft reparation of rehabilitation policy that Professor Hlengiwe Mkhize, in her capacity as the chair of the TRC committee on the reparation and rehabilitation, constructed from her direct engagement with survivor communities across the country. It became evident that the state had long decided that the people damaged by apartheid atrocities could be left to their own devices, abandoned by those it had brought to power, as if they were damaged goods, in a situation where Kulumani experience has been of a remarkable capacity of survivors to serve the nation as wounded healers. The state assumed the role of intimately promulgating ad hoc regulation on reparation to address only 17,600 victims and survivors out of 22,000 statements the TRC collected while it was active. It has been only these individuals who have received a TRR number that qualifies them for the limited reparation the state has approved. Around 100,000 proud struggle activists have received no repatriation support. They have been silenced and ignored. As they have aged, their suffering has deepened, while those in position of power turning a blind eye and a deaf ear to the calls and the appeals that Kulumani Support Group continues to receive every week. This suffering cannot be ignored at the cost of the well-being of our country, especially given that 2.6 billion remains in the Victims Reparation Fund, the President Fund, that Kulumani Support Group has had to continuously fight to protect for the purpose for which it was established through contributions of supportive donor government. Their goodwill has long dissipated. Through decades of survivors-led community-based work, Kulumani Support Group has documented more than 120,000 victim statements of apartheid-era gross human violations. These testimonies come from across Africa, rural and urban, women and children, families of the dead and disappeared, survivors of detention, torture, displacement, and political violence. The difference between 17,600 and more than 120,000 is not a technical discrepancy. It is the consequence of deliberate exclusion. It speaks loudly to the limits of original TRC process, which, with its restricted mandates, narrow definition of harm, short time frames, geographic barriers, fear, trauma, and poverty, many victims simply could not reach the commission in time or could not speak when speaking still carried danger. When TRC closed, victim did not end, but recognition did. For those excluded, non-recognition became the second injustice. Reparations were designed and delivered on the basis of partial victim population, leaving the majority of survivors outside the moral and material concern of democratic state. This inquiry, therefore, carries a profound responsibility, not merely to review past findings, but to confront the consequences of exclusion, not to treat victim recognition as close administrative exercise, but as continuing obligation rooted in dignity and justice. Kulumani presidency here is not oppositional, it is evidential. Kulumani's database is not a symbolic, it is a record of lived harm. Kulumani leadership is not abstract. It is grounded in community that have waited far too long. We urge this inquiry to resist political pressure, procedural narrowing, and the temptation of premature closure. Truth cannot be managed for convenience. Reconciliation cannot be achieved through silence. Justice cannot be postponed without cost. This inquiry has an opportunity and a duty to affirm that the lives of those previously excluded still matter, that their suffering still counts, and that reparatory justice in South Africa remains possible. We appear before you not to reopen old wounds, but because these wounds were never healed. We call for all forms of political interference to be ended. The dishonoring politics of the state and the abusive politics Kulumani has had to face at the hands of former civil society partners. We will not be deterred in our sustained struggle for justice, fairness, and dignity. I thank you.
Thank you, Mr. Lipile. We shall now connect virtually to Ms. Robin Lister on behalf of AFORED.
I've got this. Nothing to hear. Hello.
Shall we take a short adjournment? Yes, we'll take a short adjournment.
is that had this event not occurred, much of South Africa's apartheid atrocities may not have been part of our history. Like the Freedom Charter not being taught in my years at school, the crash of this plane has not been taught as an historic event for today's generation. We wish to change this. We wish to reveal the truth, to bring a stop to us being called conspiracy theorists. So, as an introduction, I'd like to highlight the background of this event. It occurred on the night of March the 13th, 1967. It involved a Viscount aircraft. The aircraft crashed into the sea approximately 1.5 to 2.5 miles offshore near Kaisers Beach, near East London, and with the loss of 25 people on board. The South African Airways flight, also known as the Rietbok crash, was a scheduled passenger flight from Port Elizabeth. All 25 passengers and crew on board were killed. Standard air crash investigation procedures with aviation experts were disregarded. The Minister of Transport, Mr. Schoeman, Mr. Van Rensburg, Deputy Minister of Transport, the Secretary of Transport then, and the Chief of Operations held tight control and gave conflicting reports of findings. Eyewitness accounts on land were disregarded for various reasons and discredited. The official findings of the inquiry, headed by Cecil Judge Marco, speculated without supporting evidence that the pilot of the plane suffered a heart attack while on approach, and the co-pilot was unable to regain control. There is still great contention about the ultimate cause of the crash. To date, the families do not believe the official report because they have so much evidence to prove questionable behavior and activity at the time of the crash. Moreover, they have been accused of being conspiracy theorists, while others propagate lies that have been told and mushroomed over the almost 60 years since the accident. This represents constant trauma, not only by the inability to lay one's dear family member to rest with dignity, but further human rights violations by accusation and disrespect. As a historical context, apartheid, as you know, was introduced in 1948. Professor Brewer, who was already in 1956 with the government, became an expert on the so-called anthropology and Afro-Bantu relations in the country. He served the government's advisory council, and in 1967, he was the acting chair of the Broederbond, but he had gained a reputation as a so-called verlichter, an enlightened person, and was said to be steering the Prime Minister Verwoerd away from the current then apartheid practices. He was beginning to doubt the future of white rule in the country. While he was a staunch supporter of the concept of separate development, he preferred to call it separate freedoms and never hesitated to criticize the government if he thought it was necessary. He wrote the speech for Prime Minister Verwoerd that Prime Minister Verwoerd was due to deliver before he was assassinated. His family believed Verwoerd was killed to prevent him making that speech. He attended Verwoerd's memorial service, telling his sister, "I'm the next one." This was in 1966. Premier John Vorster, who had been in office for about 6 months after the assassination of Verwoerd, and the foreign minister at the time, Dr. Miller approached Brewer to take up an unprecedented post as a roving ambassador to African states. He was on his Professor Brewer was on his way to discuss this post with Forster after the crash. Surprisingly, this post never eventuated. Another passenger on board was an American ANC activist who was considered a target on the plane. The late Martin Legasek had recruited her to work for the International Defence and Aid Fund, which provided financial lifeline for relatives of the ANC. Her duties were to have meetings, clandestine meetings, to find out contacts of people who needed money. A former East London mayor and apartheid security officer at the time, Donald Card, said that her briefcase was carrying information of great interest. I was a child at the time of 12, and all I remember was the talk of finding this briefcase. Sorry. So we had questionable incidents in 1967. Talk about the location. Straight away they said that the plane was found and then it was denied, and soon after the crash they impounded the radio telephone tapes indicating that the pilot knew exactly where he was. We were told there were no bodies, and then there was a report of 21 bodies. Many families were called to identify their loved ones, and then they were told, sorry, there's a mistake. A body was washed ashore 3 weeks after the crash. It was identified as being from the crash, and a post-mortem was conducted on this poor body that was a headless torso. This body was buried in an unmarked grave. No families were informed. Only in 1998, after the South African Aviation Archives documents were discovered by the families, did they identify this post-mortem, and were they able to match up and identify it. Further 5 weeks later, a naked body with a decomposed face was washed up at Queensbury Bay. This body was suspected to be from the Rietbok. It was claimed by the police, again, reportedly taken to the mortuary but for a post-mortem, but no record exists. Apparently, this body of a white male was buried in Duncan Village, a black cemetery, which never happened at that time. Finally, only recently we discovered that a fishing boat skipper, Joe Neff, related his discovery while fishing of a skeleton floating above his nets. He radioed the station. He was asked to bring the body in to the harbour, which he did, and he had arrived in total darkness. It was all to be hush-hush. This body was sent off to Cape Town for forensic identification, and he later found out it was apparently the body of an Englishman, a 23-year-old Englishman, and my goodness, my body went cold when I realised who it was. At no time were any of the families notified of these discoveries. This is not normal conduct. The families were treated like enemies of the state. Normal process is to have the airlines have an investigator. South African Airways sent their team of investigators straight away to East London. The chief investigator, James Boyd, had arrived, and to his surprise, their team was given observer status. And at the end of the week, they were told that they could go home. He called his wife to say, "I'm on my way home, but there are shady things going on." The next morning, he was found deceased in his hotel room. His body was not admitted to the mortuary, was sent to a Gauteng cemetery where his body was cremated before identified by his loved ones and before they were notified of his death. I got to speak to his son before his son passed, and his whole life had agonized about his father's death because the urn they received had black, damp stuff in it, not like a normal ash. And according to Dad's request, it was scattered, so they never got to do forensic testing. There was disappearing evidence. In the official report, evidence of a diving team and the control tower, many things that were not included in the official document. So it comes to the TRC Commission in 1998. Many of the families formed a group called AFORA, the Association Families of the Rick Book Tragedy. It was headed by Helen Brown, who did an immense amount of work, and still groping in the dark. Submissions were made to the TRC, but the families were referred to the civil aviation. They sent the submissions to Bishop Tutu, and to their horror, they never got any reply. They only found out via a radio interview that they were not included. We have found, so despite all this evidence, no reason was given for the failure to investigate. They did suspect the involvement of the Bureau of State Security. There has been much new information since 1998. We have official documents from the government proving that there were 21 bodies. We have many other documents proving utter secrecy. And our feeling, I won't bore you with all of the much information that has been revealed, but we have a request for a full investigation to first of all prove that this was not normal, it was not an accident, and to prove as much as possible. Obviously, many of the people are no longer with us, many of the family members have passed, but the generations continue. We wish to have a correction of history. So in the absence of definitive resolution regarding the cause of the crash, there are suspicions, but I do not include anything without proof. The circumstances of this crash have led to much speculation. The Rickbock air crash is a stark reminder of the need for a comprehensive and transparent process to address all stopped TRC cases. We urge the Commission to prioritise this case to ensure the truth is revealed and that all victims receive the justice they deserve. Time is the enemy of those involved in this case, which occurred so long ago. We are keen to make use of the scant living witnesses. In conclusion, I make a solemn plea to Your Honour that you use your powers to protect our human rights and that of the victims by granting a heritage status to this crash site and the unmarked graves, which are currently the subject of social and commercial activity that we have begged to not go ahead. I thank you for your time, and I look forward to the outcome of this inquiry.
Thank you, Ms. Lister.
Thank you.
Are we ready to receive the virtual opening statement of Mr. Ganda?
Not yet.
We'll take a short adjournment. Oh, he's not there. Okay. Yeah. In that case, we'll receive the opening statement of Mr. Siminya.
Chairperson and Commissioners, as evidence leaders, we find it unwise Chairperson and Commissioners, as evidence leaders, we find it a little unwise to do an opening statement, particularly because there are crucial witnesses that this commission directs must be heard. We must obtain their statements, and we must accordingly then make a coherent strategy around these matters. But we, however, think it useful that we have some introductory remarks about the difficulties associated with the conduct of the work of the Commission. And I start by reminding all of us that this Commission was proclaimed and published 29 May of last year. That's a period, now that we're sitting today, longer than the original lifespan of the Commission and its work. Now, I just want to give us context. The work of the Commission is intended to cover, and I paraphrase, any interference with the prosecution and or investigation of TRC cases. And I hazard a guess that of the 7,000 odd applications for amnesty that served before the TRC, it is only 5,000 of which were refused. And I hazard a guess again that the Galata group may prove to be a tip of the iceberg, because we have to factor those people whose number we don't know, who never even bothered to apply for amnesty. We must see why it is that those cases have to date not been investigated. And as the terms of reference tell us, and I propose to read the relevant part, the Commission is appointed to investigate matters of public and national interest concerning allegations regarding efforts or attempts having been made to stop the investigation or prosecution of the TRC cases. The Commission must, in relation to the period since 2003, inquire into, make findings, report on, and make recommendations concerning the following: guided by the Constitution, relevant legislation, policies, and guidelines. 1.1, whether, why, and to what extent, and by whom, efforts or attempts were made to influence or pressure members of the South African Police Service or the National Prosecuting Authority to stop investigating or prosecuting TRC cases. Now, we're making this point with deep frustration, because you would have expected that entities, particularly the state entities, and particularly the South African Police Service, and particularly the National Prosecuting Authority, would have been alive to this work alive to the relevance why they are mentioned eo nomine, specifically rather, in the terms of reference themselves. They would not have had to wait for anything. But what we did, we also used the rules of this commission, in particular Rule 3.1, which I will also paraphrase, which places the responsibility on the evidence leader to collate and place evidence before this commission. That is our primary function unless directed differently by the chair or the policy itself points differently. Now, in the discharge of our attempts at doing this work, we issued out a request for information which covered a whole plethora of individuals, from the two former presidents, from some members of the NPA, all the commissioners of the police since 2003 to date. And it is disheartening and disconcerting that as we see today, we have not received one statement from the South African Police Service, not one, of all the commissioners that have occupied various periods during the 2003 to date, not one single statement. I am now given a document dated the 9th of February 2026, which I'm advised we received yesterday, only yesterday. It too does not give me statements. It promises that I will have statements of few of those indicated persons by the 20th. This is hardly helpful. Now, if we consider that at the very least, state actors would have been the first people to assist the work of the commission, on the contrary, that's not happening. Now, we also issued what we call Rule 3.3 notices. By that, again, I'm rephrasing, by that it's an obligation on the commission that if there is somebody implicated in a statement of witnesses such as we have heard from the Galata group, the duty we have is to bring it to their attention and to say, look, we are giving you excerpts of statement, but we'll give you statements, but we will identify excerpts of those statements which make reference to you and which implicate you. Now, Trust, Chair and Commissioners, of the RFI's request for information, we only received responses of 20% of those issued. We also issued 3.3 statements. This is the one where we invite the implicated persons to respond. Only 10% of those have been responded to. Now we're talking about people who occupied critical government positions, from the presidents, the ministers, the NPA, the chairpersons of the Portfolio Committee on Justice. No response at all. And we say it is disconcerting because you would have expected them, in particular, to be upfront and helpful. Now, we are mindful of the powers that the Commission has, in particular under Rule 3. We can go to Rule 3.10. It says the chair has the power to call for this evidence. We have been slow because of a whole number of complications to have to issue out documents of compulsion. We have also under the regulations the power to exercise in compelling that information to come forward. No less, we have the powers under the Commissions Act, that of subpoena and compelling witnesses to come and appear before this commission. But the rhetorical question asked is, why do you have to compel such senior state officials to help? It is not happening. Now, Chair and Commissioners, given the limited life of the Commission, we know we are constrained to do what we must do within a time frame whilst the Commission is standing and alive. But for the extension of the first life of the Commission, we would not be sitting today. And I harbor a suspicion we might just get to the end of the second half of this Commission without discharging our responsibilities. And it would be in part because state actors don't want to help. This is at least from the distance from where I'm reading the scenario. It did not help also with our time management that we had to consider 2 recusal applications that virtually rendered the first term of this Commission's hearings redundant. We were left with nothing, and now
Is it two recusal?
2 recusal applications.
3.
2.
Yes, it was my recusal
Yourself
and that and that of the
and then the
chairperson.
2 presidents. Okay, doesn't matter.
Okay, yes. That consumed a considerable amount of time for the work of the Commission to commence. When we were about to commence the November of last, then they started these applications. Now, we are being threatened that the 2 presidents will be bringing an application for review.
You have not been threatened. There has been one filed.
With another threat to follow, as
Yes.
I understand, but Chair, you're correct. Already we have been served with an application for the review of the chairperson's ruling in relation to her recusal as a chair. But all I'm saying about that is that that is also in the wind a possibility for the work of the Commission to be delayed. I don't want to anticipate how the other review application will look like. We have considered what this one that is filed is saying, and for that reason, we are minded to proceed with the work of the Commission until such time and unless such time a court of law tells us we cannot. So we were having in mind the lineup of witnesses that would commence beyond these opening statements, and I would have to announce a little adjustment to that timetable. We were indicated to start with at least 4 witnesses of the Galata group, with Mr. Lucanio Galata being the first of those to come. Logistics are now suggesting differently, particularly with the work he does and the fact that we've got the State of the Nation address tomorrow. So the thinking is to try and bring Madam Simelane first, but even that seems to be okay, but cannot happen this afternoon. So, Chair, I'm highlighting that we are going to be forced to use powers of compulsion to obtain the necessary material to enable us to discharge our function.
Yes.
Yes, Chair.
Thank you, Mr. Simenya. Mr. Vani, may I please come to you with regard to the sequence of the witnesses you wish to lead?
Yes.
Am I correct that Ms. Simelane will be the first to start?
Yes, Madam Chair. We originally had proposed starting with Mr. Lucanio Galata, and he was scheduled for Friday. But given that the opening statements are now concluded, we asked whether he might be available tomorrow, but because he's a senior journalist with a broadcaster, he's tied up with the Sona address tomorrow. So he's requested to remain on schedule for Friday. I have spoken with Minister Simelane, and she has agreed to make herself available tomorrow morning. Unfortunately, she's not in Johannesburg today.
Yes. So tomorrow at 9 o'clock we can start with Mr. Simelane.
Miss.
As the Commission pleases.
Yes. And Mr. Kalata will then follow on Friday.
That's correct, Madam Chair.
And from there, where do we go?
We have supplied the evidence leaders with a very rough draft schedule. If my memory serves me correctly, then on Monday we can commence with Yasmin Suka, a former TRC commissioner, followed by Dumisa Nsebeza. We have been in discussions with Mr. Nsebeza, and he might request the Commission for permission to testify remotely, just depending on his condition, and we will advise the Commission in due course.
Yes, you'll make the necessary application in due course.
Indeed. There are further witnesses. I don't know if you wish me to take the Commission through them, but we have supplied a rough schedule to the evidence leaders.
Yes.
Chair and Commissioners, of course we are trying to keep this a little fluid because we are mindful that the Chair, in terms of Rule 11, has the power to change the sequence if so minded and good cause exists for it. But for now, this is the business of the day, Chair.
Thank you. Thank you, Mr. Vani.
As the Commission pleases.
Yes. We have come to the end of the proceedings in respect of the opening statements. We'll adjourn for the day and reconvene tomorrow at 9 o'clock.
As the Commission pleases.